Good morning, Your Honor. Stephen Pfaff for the defendant, appellant Comcast. Your Honors, any plaintiff that goes to trial on the issue of credibility of witnesses or the credibility of medical exhibits runs the risk, I suggest to you, that a jury is going to view that evidence differently from the plaintiff. That's precisely what happened in this case. There is no evidence whatsoever of juror passion, partiality, prejudice, or misunderstanding of the facts as presented by the court during jury instructions. What there is, however, is evidence in the record. The record is replete with evidence of instances of treatment while the plaintiff stayed in the hospital for approximately 18 days that was not related whatsoever to the motor vehicle accident of December 5th, 2003. Most of that treatment.
Before you get there, let's I'm sorry.
How can you say that the jury award was not for medical expenses when to the penny it was what the defendant's medical bills
I'm
were?
sorry if I said it wasn't for medical expenses.
No, but I'm asking you, that's what your brief suggests.
I'm suggesting that simply because they came back on the number for medical expenses doesn't mean, although it may be a reasonable inferences, there are other reasonable inferences, which I will go into.
But
doesn't mean that they
93 cents?
simply.
How did they get to 93 cents?
Well, they gave
I
an
take it
award
your point
that
is that they gave it for medical expenses and rejected claims for emotional distress and so on related to this accident.
I think what the jury did was they could have considered expenses. They could have considered pain and suffering on this type of fact pack. What they could have considered was that the extended treatment and stay of the plaintiff was not related to the motor vehicle injuries sustained on December 5th, but for a history of alcohol abuse and alcohol withdrawal. The record has much evidence in it that the plaintiff was treated with drugs to limit his alcohol withdrawal symptoms. On the 5th day of treatment, on December 10th, 2003, 5 days after the accident, the plaintiff got into a fight with attending nurses and physicians. The records indicate he was agitated, he took a swing at nurses, and he had to be placed in a 4-point restraint, which caused the nurse to code a code gray, which brought in an assessment, an alcohol consultation evaluation, which said this individual is suffering from alcohol withdrawal.
Well, isn't it more likely, though, that what the jury did here was that they probably couldn't decide who was at fault here. They probably accepted some of your argument, so they just gave him his meds and said no pain and suffering. And then the judge said it was against the weight of the evidence in this case not to have awarded him any pain and suffering. And
that's, Your Honor,
why should we even get there, though? I mean, how can you take the editor, accept it, and then appeal?
I suggest you can, Your Honor, because the cases cited by my brother indicate the Donovan case, the Supreme Court case.
Why is a remitter different? Why isn't it just the flip side?
Well, I think I'm not really sure why the remitter is different, Your Honor, except that the history of the editor in Massachusetts is only 30 years old, beginning with the acceptance of the editor as being constitutional under Freeman versus Wood. The history of the remitter goes on for 100 years, as the Donovan case from the Supreme Court indicates. I suggest to you that the cases I've cited in my reply brief, the Brooksbank versus Epstein case and the Allard versus Springfield Terminal Authority case, indicate, in fact, that's exactly what you're supposed to do. In Brooksbank versus Epstein, what the defendant did was appeal from the decision awarding the editor without waiting for entry of final judgment of the editor. The appeals court said, you can't do that. You've got to wait for entry of final judgment. Entry of final judgment comes...
Did you ask the judge to report the question?
I did not ask the judge to report the question, Your Honor.
You could have, right?
I could have,
in other words,
yes.
you could have said, we're not going to accept the editor, but we want to appeal this decision. We don't want to have to undergo a new trial before we do that. I mean, that was an option, wasn't it?
It was an option, Your Honor.
And another option, wouldn't it have been for you to have declined the editor and then just proceeded with a new trial on the issue of damages?
That's correct, Your Honor. But then
You could have done that.
I could have done that, but then you're appealing from the second trial.
Wait, I'm sorry. Are you saying that you could not seek a new trial and then appeal from the judge's finding?
I'm suggesting you could, if I were to go to a new trial, if the defendant were to win that, the additive becomes a non-issue. If the defendant were to go...
My question is different. Could you not have basically declined the additor and then appealed the finding by Judge Fishman that there should be a motion for a new trial?
No, I don't believe so at that point.
I was the trial judge in Clifton, which is exactly what happened there, and this court took that case. So why is Clifton not a direct contradiction to that argument, that you could have denied the additor and then appealed?
Because I suggest to you the Brooksbank versus Epstein case from the appeals court indicates that I cannot appeal that decision of a denial of additor. I have to wait until final entry of judgment, which comes in two forms. Either I accept the additor and the judge enters final entry of judgment with the additor and I appeal it, which I did, and I suggest to you the Allard case says that, or I wait and go through the expense of a second trial, at which point the additor becomes a non-issue and I'm appealing the verdict from the second trial.
So this court was wrong in Clifton to have done what it did, to take that case when there was a denial of the additor by the parties.
I would suggest that it was, Your Honor, yes. Getting back to the evidence here presented, I would suggest that it's overwhelming that the treatment and stay with respect to the plaintiff was twofold. It was for motor vehicle injuries sustained on the 5th of December of 2003, which were uncontested by me at all points of the trial. During my opening and during my closing, I suggested I would not contest the motor vehicle injuries. However, I did contest the extent of treatment and the type of treatment received by the plaintiff.
Did you really?
I did. I suggest.
I mean, so you argued to the jury that the treatment here, for which there were financial bills, was in some part not related to this accident and therefore should be discounted by the jury?
I argued to the jury the fact that the evidence indicated that the plaintiff's stay in the hospital was not related to entirely the motor vehicle accident injuries sustained on the 5th of December.
And that wasn't an argument made about liability. That was an argument made about damages, that you shouldn't give the defendant these damages for medicals because his stay was not all related to the injury.
Correct.
So that was, okay. I haven't seen the transcript, so I don't know.
And the evidence points out in a number of instances, just in fact, that the plaintiff was treated for not injuries sustained as a result of the MVA, but because of his history of alcoholic abuse.
You're referring to his taking drugs for alcohol withdrawal on the 12th of December, which is 5 days after this accident.
Correct.
So you're saying then that the 13 days that he spent after those drugs had nothing to do with the accident? It had to do because of the alcohol withdrawal?
Well, it doesn't. It's later than the 12th, Your Honor, too. The 17th of December, there was administered a dose of Narcan, which the plaintiff's own medical expert witness testified is given to individuals who are suffering from alcohol withdrawal.
But even if you're right, doesn't the defendant take the plaintiff as he finds him? And this particular plaintiff had an alcohol problem, and the accident and the withdrawal are part of the same cause of the accident.
But I suggest that that's not true, Your Honor. I suggest to you that the cases that suggest that pain and suffering damages have to be awarded look at precisely what type of condition was the plaintiff in. By way of example, if an individual were to fall and break his hip because of negligence of a healthcare facility, but at the same time that individual was staying at the healthcare facility, that individual had terminal cancer, there's an issue as to whether or not that individual suffered pain and suffering with respect to the cancer condition or whether the individual suffered pain and suffering with respect to the fall. In fact, there's a case on that point that recently came down in Superior Court, Justice Roach presiding just a few months ago, with that exact same fact pattern.
But that's not this case. This is a case where it is the, just to take your view of the facts, it is the accident that sort of catalyzes the withdrawal. So you can't, it's not that I was suffering and in pain from cancer and this was on top of it. this accident brought about that exacerbated condition because of who he was.
I would suggest to you, Your Honor, that you would need an expert witness to make that assessment. The plaintiff did not have that. What the plaintiff had simply was an expert witness to say that the injuries sustained on the date of the accident are the direct and causal result of the accident. My point here was that there's a multitude of possibilities that a jury could infer, or you could infer, from looking at the verdict. Because I've suggested to you in the Rosemi versus Talbot case.
That's a very different case, though.
I don't think so, Your Honor. They came back and awarded chiropractic damages of $2,400 and awarded no pain and suffering whatsoever.
Well, as I read the decision, it seemed as though the facts in terms of the connection of the plaintiff's pain and suffering to this were just extremely distinct from this particular case.
I don't believe they were, Your Honor.
Well, there wasn't evidence in the Rosemi case to support the pain and suffering the way there was in this case.
Correct, yes.
So that distinguishes the two cases?
It does. It does, Your Honor. But
can I ask you this?
Certainly.
Was the plaintiff's blood alcohol content taken at the hospital, tested?
Yes, it was. That's also in the record as too. It comes out on its volume.
So what was it?
It was 23 milligrams per deciliter, ETOH.
No, what, .0 what?
Oh, it would have been somewhere between .037 and .04. My expert witness would have opined that it was a .04. The actual number was .037, but it's rounded in all instances. That's another example, Your Honor, as to why I'm here on appeal. They excluded my expert witness, Dr. Perrine, who was going to testify.
Well, how your expert witness can't tell whether the alcohol contributed to the accident at all.
That's it. All my expert witness was going to do was not go to the issue of direct causation. He was not ever going to say, this is the reason why the accident took place.
He was going to talk in generality.
He was simply going to present that this is a factor, that there's a methodology here that's been well established, which the trial judge accepted.
Don't you think that the average juror knows
that?
If that's all your expert is going to say, that alcohol impairs your facilities somewhat, do you think that's beyond the knowledge of the average lay person?
An alcohol can impair your facilities after you've had it at 4 o'clock in the afternoon. It could impair your facilities minutes thereafter. But I'm not sure the average juror knows that if you consume alcohol 12 hours before the accident, which is the situation here, that alcohol can affect your fine motor skills and attention span 12 hours after you consume it. No, I don't think the average juror actually knows that.
Does that depend to a great extent on the person, on how fast he or she metabolizes, et cetera?
It does.
So since your expert didn't know any of that, didn't test this person, how can he opine on that?
Well, my expert was able to, based on his experience in testing individuals with this type of alcohol history and this type of weight and this type of alcohol consumption X amount of time before an accident, he was able to say what the alcohol amount was in the body and what that amount meant for an individual's fine motor skills and attention span.
But how was the jury going to make the connection between what your expert was saying and this particular defendant?
I'm sorry, Your Honor?
How is the jury going to make the connection between the general statement that your expert made and the driver of the car?
I believe the jury was going to hear the alcohol level of the plaintiff. The jury was going to hear, based on my expert witness history and study, that this is what they find when individuals have consumed X amount of alcohol over a span, and there's a delay of alcohol.
Well, some individuals have that experience, not
right.
all.
Not all.
So how is the jury going to make the connection between the general statement and the driver of the car?
The jury is going to consider it as a factor, Your Honor, not the ultimate cause of...
A speculative factor, the possibility that there might be some connection between them?
Yes, Your Honor, the possibility that there might be some connection between them. Simply a factor that they could consider what was going on in the driver's body at the time that he was at the intersection. It did not go to the ultimate causation of the automobile accident. It simply went to a factor that existed in the body of the plaintiff at the time of the accident.
But how are you prejudiced when the jury found the plaintiff negligent? And that's the best you would have gotten, is a finding of negligence, which you got. So I don't understand why.
50% worth.
It was, Your Honor, but I do raise an issue there too. I think that the playing field is tilted in favor of the plaintiff when you instruct the jury that if the plaintiff is found to be 50% or more negligent, you won't recover. You don't do that.
Isn't that what almost every, or maybe every Superior Court judge does?
It's left to the discretion of the judge, Your Honor. I've had it in my experience where they have not, based on argument by me at sidebar indicating that they should not do that. We don't do it with respect to telling the jury that there are PIP insurance offsets to be made once the jury verdict comes back.
So you're asking us to change the rule. Is that what you're saying?
I'm suggesting, Your Honor, that absent a specific instruction from the jury on the issue of comparative negligence and what a plaintiff will take, then it should not be given. And I think I make the argument in the last argument section of my brief as to why such an instruction should not be given, because it tips the playing field in favor of the plaintiff.
Thank you, Mr. Pack.
Thank you, Your Honor.
Good morning, Mr. Casby.
May it please the Court. Allow me, please, to say at the outset that this was a tough case, and it was hard fought by both sides throughout the course of this trial, and it clearly was hotly debated during the course of deliberations by the jury. Having said that, one thing I can assure you that was not debated, not contested, not fought during this trial was how badly Robert Baudanza was injured. Not a single contested word. The only thing that Comcast tried to bring out during the course of this trial was that this man had a blood alcohol of not .037 at the time it was drawn, but 0.02. And I invite you to read the transcripts.
What was the last number?
.02, Your Honor.
You say that's what it was?
I say that's what it was at the time it was drawn, after they met
at the time of the drawn, but obviously the expert was going to testify that you work backwards to determine what the alcohol level was at the time of the accident.
By extrapolation, yes.
Perfectly accepted science.
Without fail. And I invite you to read that transcript of the hearing that the trial judge held. And I think it supports the reason why the evidence was excluded. The point being here that there was no contest, there was no objection to the exact amount of the medical bills that were put in. It was only after, when the plaintiff was looking for a new trial or an editor, that theory was advanced. Only during the post-trial motions was that theory.
What theory advanced?
That the exact amount of the medical bills could somehow be contorted into all of the damages that the jury wanted to give.
No, but that, Mr. Casby, that's not how I understood the argument. What I understood the argument was it's the precise amount of the medical bills, but the jury faced with, as you said, the jury knew this man was seriously injured.
Yes.
And the jury had before it evidence, as I understand it, that there were lots of reasons, I said emotional distress, pain and suffering, lots of reasons why the plaintiff was experiencing unusual pain and suffering. And essentially, it seems to me that if we go along with the judge, we are saying in any case where the plaintiff is injured, the jury must give pain and suffering damages.
I think what the judge was trying to say, and what the judge did, was recognize that on the facts of this case, Your Honor, this man was so badly damaged.
No, I understand. So the defendant is saying there were all kinds of reasons for the pain and suffering, and the jury decided, which we let juries do, that they didn't want to award pain and suffering. If we go along with the judge, it seems to me that as a matter of law, we are saying where the jury is presented with evidence that somebody is badly injured, there must be pain and suffering damages.
But isn't that the judge's role? Isn't the judge...
As a matter of law, in every case, if the jury has rejected pain and suffering, we must award pain and suffering?
Certainly not, Your Honor. I'm not suggesting that at all. And in fact, this judge did not allow an editor For a loss of earning capacity or
No,
dysfunction?
I'm talking about pain and suffering. Your claim is it is uncontested. The jury knew he was badly injured. And essentially, it seems to me the judge is saying in those circumstances, a jury must award pain and suffering.
Depending on the facts, I would agree. Yes, Your Honor. I think that should be the law.
Aren't you saying that the this is I haven't read the transcripts either, but it seemed to me that the weight of the evidence was that the pain and suffering, whatever may have been the contribution of alcohol withdrawal, I'll put that to one side. The pain and suffering, as I read it, as it went on, had to do with things that only came from the accident. The DVT, do I have the initials right?
A deep venous thrombosis, yes, Your Honor.
Yes, and the collapsed ribs and the not being able to sleep. I mean, as going forward in a permanent basis, that's only related to the accident.
Absolutely, and it was uncontested. And that's what I'm...
And that therefore the judge found that it was against the weight of the evidence not to award anything for pain and suffering.
Yes, Your Honor. Having in mind...
Given this evidence.
Having in mind that during the course of a day and a half of jury deliberations on a 4-day case, he instructed the jury specifically that they are to answer the questions in the order in which they were presented. That last question was, what are the damages? That issue was decided about 35, 40 minutes after their last question to the judge, to the court, dealing with comparative negligence. It is pretty clear that they were fatigued. We were going to lose a juror the following week because he was going out on vacation. That does not mean that we were going to lose the jury entirely. But the jury didn't know that.
So you're saying the jury just forgot?
I'm saying
they just didn't do it right? Or I mean, if the jury made a conscious decision, we're not awarding pain and suffering
That's
damages.
my point.
Is that somehow an improper verdict?
On this evidence,
yes.
You're saying yes. The answer
On
is
this
yes.
evidence, yes, it is. And I think, I believe, Your Honor, that they did not get it right. I believe they got fatigued and they gave up. And they
I'm sorry, I missed the last point.
I believe they got fatigued and they gave up. I think it was as hotly contested in the jury room as it was in the courtroom.
But you would say, I think, even if they did intend not to grant them on this evidence, the whole weight of the evidence was that fairness demands some award of pain and suffering damages.
Without question. Without question. And that leads to the nature of this appeal. I think that this appeal is an attempt to avoid another jury unburdened by the liability issues that presented during the first trial.
What do you say to the argument that the appeals court case, Epstein, whatever it is, Brooksbank versus Epstein says you don't have any right to appeal from a, this kind of situation, either accept the additor or there will be a new trial, and therefore the only way to get yourself heard on appeal is to do exactly what Comcast did in this case?
Well, then again, the court presented the other alternatives that are, in fact, the way to go here. By appealing here, in the first instance, Your Honor, what the defendant did was accepted the additor. It did not need to do that. All it needed to do was say, we don't think that that's reasonable, we'll face the jury again. Receive a verdict, and then appeal.
Right, but you can see how somebody in Comcast's shoes or somebody else's shoes that, anyway, that is not exactly a inviting alternative to go through a whole nother hotly contested trial. I mean,
it would not be all that, it would be simply on a sole issue, pain and suffering, as the judge allowed in the motion.
Yeah, but let's assume that we agree that the attitude was proper, right?
Yes.
So we've had to expend all kinds of resources going through another trial where maybe the issue of the attitude doesn't get addressed.
Well, I believe my brother's appeal requests that you examine the additor itself. I
Yes.
believe he's asking for relief from the additor.
Yes, but that's my point.
He's asking for the motion to...
If
sorry.
he accepts it in order to have, if he rejects it,
Yes.
then there's a new trial, correct?
he could ask to have it reported.
He could ask to have it reported.
There were a number of alternatives available to my brother, Your Honor. This was not one that, under the law, was the proper way to go.
Do you believe he could have appealed the grant of a new trial if he rejected the editor?
No, I don't believe he could. I think what he'd have to do
Is that what
have
happened
his
in
trial
Clifton?
and then go up.
Is that what happened in Clifton? Do
You know, I honestly don't remember.
Okay.
I honestly don't remember. I do recall that there are two justices sitting that did give the comparative negligence instruction and its consequence in cases that I've tried before them.
Yeah, but that's a separate point.
May I proceed?
Yes, of course.
Thank you. On the issue of excluding the expert, I think it's an abuse of discretion standard. I think once Your Honors read the transcript of the hearing that was conducted, the voir dire of Dr. Perrine, it will become abundantly clear that this man's testimony was nothing but speculation, and that he had no business being a witness in this trial. Again, as to the comparative negligence, Flood versus Southwind applies. It's good law. It should stay that way. And finally, with respect to the editor, this court makes the rules. And the rules say if the trial judge thinks that you deserve a new trial, you have an option. You can accept an editor, or the plaintiff or your opponent, either remitter or editor, gets a new trial. And then you take the whole business up and you go from there on your appeal.
Can I ask you,
Yes, sir.
the editor that the judge proposed was $400,000 for pain and suffering.
Yes, sir.
Where does that number come from? Is this something the judge in his experience thought would be a good number for this
Yes, sir.
case?
It was not
That's
a
it?
number I suggested.
So it didn't come from the evidence.
I think it came entirely from the evidence. But I think it was based on the judge's experience that that was a reasonable measure of damages to redress this man's injuries.
Now, reasonable or the minimum that would be reasonable?
Just as I am loath to trying to think of what juries do, I would not want to get inside the man with the robe, Your Honor. I think that it cannot be argued that it's an unfair amount, and I accept it. My brother accepted it.
Going back to a question that the Chief Justice asked you, the issue before us, as I understand it, is not whether a plaintiff is always entitled to pain and suffering, but whether or not Judge Fishman's abused his discretion in finding that it was against the weight of the evidence in this case to permit the award to be as small as it was. Is that how you see it, or do you see it differently?
I apologize, and if I misstated what my thought process was earlier, Your Honor, I apologize on that also. I believe that Judge Fishman looked at the evidence as a whole and saw what the pain and suffering was here, and then looked at the way the jury deliberations played out and looked at the exact amount of medical bills and found that they did not do their job, and that on the evidence of this case, on the facts of this case, this man's pain and suffering was ignored, and it should not have been.
At least after they found liability. They
Yes,
found
sir.
liability, 50% liability for each party.
Yes, sir.
And they found, presumably, that the medical bills were a fair and reasonable amount paid for medical services rendered as a result of the accident.
Yes, sir. And I may add, and I invite you to look at those medical records, there is only one mention of alcohol withdrawal, and it was ruled out 3 days later. My expert, Dr. Wagner, testified that Narcan and other drugs which were delivered while this man had what's known as a flail chest, a ruptured diaphragm, a lacerated pancreas. While this man was lying in the ICU, he became combative and he became disoriented. She also testified that that happens in the ICU, especially when you have severe injuries such as this man suffered. She also testified that those medications can be given for alcohol withdrawal. She did not testify that they were given for alcohol withdrawal in this instance.
But even if they were, even if he did experience alcohol withdrawal and that contributed to his response, what difference would it make?
I don't think it makes much difference at all, Your Honor. I don't think it does. I think you take the plaintiff as you find him. And in this particular case, I mean, the records just clearly bear out that he was in there because he had several surgeries and he needed extensive ICU care because of the nature of his injuries. I think what we're discussing here is an argument advanced after the fact by my brother to deny the motion for a new trial on damages.
And as far as, there were some questions too about whether the judge's selection of $400,000 was, I suppose, based on the evidence, but or too speculative. But it's no more speculative. Wouldn't you say it's no more speculative than any pain and suffering award?
That's correct. That's correct, except that it's made by a seasoned trial lawyer and now a seasoned trial judge.
Thank you, Mr. Katzman.
Thank you very much, Your Honor.